The Cincinnati and the Dayton contract version May 20 of 2025. And we are going to knock out a lot of sections, namely because there's just not a lot of changes that have taken place. But we're going to go through sections 23 through 32. From the attorney's perspective, section 23, they added a capital contribution clarification for alignment with section 10. Under section 25, agency disclosure, they clarified that the disclosure is an integral part of the contract. Section 28, they replaced the words fax or internet with electronic, since really faxing doesn't take place anymore. And then 32 talks about indemnity, which was expanded, hold harmless language to be of greater protection. So let's kind of jump into it. So section 23 talks about conveyance and closing. What you're putting in line 474 is the title company and phone number of the entity that's doing the closing. I find that this doesn't get filled in a lot, but when you get down to line 489 under number 7, the following assessments, certified or otherwise, shall be blank. If there are assessments, then those would go there. Line 492 is the closing. The date of the closing shall take place on such date. June 30th, July 15th. Make sure you put a year to go with it. I wanted to also point out that starting here in line 492, notwithstanding anything to the contrary, in the event that the buyer and the seller are proceeding in good faith, performance under this contract and closing cannot occur due to an occurrence or circumstance out of the direct control of either party, i.e. COVID is something that would have happened. The date of the closing shall be extended for a period of up to 7 calendar days. So, unless otherwise agreed, such extension shall extend the terms of possession and occupancy by an equal number of days. And then it puts in here, make deed payable to, and that's where you would want to ask the buyer, how do they want their name on the title? So, people may go by a nickname. That's not necessarily the name that they're going to want to close in. So you would want to ask that question. And so then down in section 24, we talk about possession and closing. And so what you're going to see most of the time in contracts is line 499, the box check that says at closing. So when that's checked, that means that when the buyer and the seller convey the property, that the property will transfer keys at that point directly to the buyer. If line 500 is checked, you're checking that at a certain time frame on a certain date, whereby the buyer is taking possession of the property. And in line 502, it talks about until such time the seller shall have the right to possess and occupy free of rent unless otherwise specified, but shall pay for all utilities. So whatever that time frame is, the seller is staying there rent free unless you have agreed to some other terms. Line 504 talks about the seller shall provide keys and door openers and information for items regarding codes programming no later than the time of occupancy. The seller acknowledges and agrees that prior to the buyer taking possession of the real estate, the seller shall remove all personal possessions not included in this contract, shall remove debris. Again, remember, we're broom swept condition. If the seller fails to vacate as agreed in the contract for any attached post-closing occupancy agreement, seller shall be responsible for all additional expenses, including attorney fees, incurred by the buyer to take possession as a result of the seller's failure to vacate. So that's got some teeth to it if for some reason that happens. In 25, agency disclosure, buyer and the seller acknowledge having reviewed the state mandatory agency disclosure statements, which is an integral part of the contract. 26, if there are any company-specific provisions, you would list those here. In 27, it talks about the MLS and public acknowledgement of this public record information. The buyer and the seller acknowledge that the realtor shall disclose the sales information to any multiple listing service, participants, affiliates, government agencies, so on and so forth. Seller and the buyer acknowledge that sales information is public record and may be accessed and used by entities both public and private. Section 28, sole contract. The parties agree that this contract constitutes their entire agreement. No oral or implied agreements exist. Any subsequent conditions, amendments, and or other modifications to this contract shall not be valid and binding upon the parties unless in writing and signed by all parties, upon which such written agreement shall become an integral part of the contract. Section 29, general terms. This contract shall be interpreted and construed in accordance with the state law of Ohio. Any and all seller certifications, representations, and warranties contained herein shall survive the actual date of the closing for a period of 1 year. Section 30, seller non-foreign status. So Section 1445 of the IRS code provides that a transferee of a U.S. real estate property interest must, under certain circumstances, withhold taxes if the transferor is a foreign person. So if that applies to the situation, that's what that's for. Section 31 just basically says that electronic signatures are valid means of signing. Section 32, line 545, seller and the buyer recognize that the realtor's involvement in the sale are relying on all information provided herein and supplied by seller or seller's resources and the buyer and their resources in connection with the real estate, and agree to indemnify and hold harmless the realtor, their agents, and employees from any claims, demands, damages, lawsuits, liabilities, costs, expenses arising out of any referral, representation, or misrepresentation or concealment of facts. Seller and the buyer represent and warrant that other than the reference in this contract, they have not engaged in any other representative, real estate agents, or brokers in connection with this real estate transaction, and shall indemnify and hold harmless the other party from the other party's agent and brokerage from any and all liability, loss, damage, including reasonable attorney fees, related costs arising out of, resulting from any and all brokerage compensation claims related to the sale of real estate. That completes sections 23 through 32.